Hi, everyone. Welcome to the New Jersey Self-Advocacy Stay Healthy at Home webinar series. Today's topic will be Let's Make This Work, Employment and Accommodations under the ADA. My name is Kelly Mulvaney, and I am a Training and Technical Assistance Coordinator for the New Jersey Self-Advocacy Project. NJSAP has been a division-funded program of the Arc of New Jersey since 1983. NJSAP supports the state's largest network of self-advocates and self-advocacy groups. NJSAP provides comprehensive training and resources to self-advocates, direct support professionals, and agency personnel. We have partnered with the Healthy Lifestyles Project, which is a program that teaches students and adults with intellectual and developmental disabilities about living a healthy life. If this is something that you're interested in, feel free to reach out to the NJSAP team if you'd like to schedule a training on any of these topics that you see here. We continue to host virtual training sessions over Zoom, GoToWebinar, Google Hangouts, and conference calls, so that we can accommodate any program needs. In the interest of time and respect for individual privacy, we will not be addressing individual legal questions related to the ADA during this webinar. We will be discussing details about the ADA as it relates to general life, employment, reasonable accommodations, etc. So if you have specific questions you would like to consult with a legal professional, we would recommend that you reach out to the legal protection and advocacy organization here in New Jersey, which is Disability Rights New Jersey, DRNJ. If you reach out to them, if you have any specific questions, they will be able to help you out with a legal professional. And if there's any general questions or comments, feel free to leave them in the questions box. Today, we will discuss Title I of the ADA, how to request an accommodation at work, how to file a charge of discrimination if your accommodation was denied or if it was overseen, and some of the enforcement actions that the ADA has already taken so that we can see what happened in the past and how we can make employers follow the ADA in the future. The Americans with Disabilities Act, the ADA, was signed into law on July 26, 1990 by President George H.W. Bush. The ADA is one of America's most comprehensive pieces of civil rights legislation that prohibits discrimination and guarantees that people with disabilities have the same opportunities as everyone else does to participate in mainstream American life. Things like enjoying employment opportunities, purchasing goods and services, and participating in state and local government programs and services. The ADA was modeled after the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, sex, or national origin. It was also modeled after Section 504 of the Rehabilitation Act of 1973. The ADA is an equal opportunity law for people with disabilities. To be protected by the ADA, one must have a disability which is defined by the ADA as a physical or a mental impairment that substantially limits one or more major life activities, a person who has a history or a record of such an impairment, or a person who is perceived by others as having such an impairment. The ADA does not specifically name all of the impairments that are covered under the ADA. So Title I of the ADA, as we learned last week, is all about employment. So this prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other items, conditions, and privileges of employment. The ADA covers employers with 15 or more employees, including state and local governments. It also applies to employment agencies and labor organizations. So who is in charge of all of this? The U.S. Equal Employment Opportunity Commission, EEOC, and the Department of Justice, DOJ, share responsibility for enforcing Title I of the ADA. Complaints alleging employment discrimination should be filed directly with the EEOC. The EEOC will bring suits against private employers, and the Department of Justice will bring suits against state and local government employers. The Department of Justice is committed to enforcing Title I against state or local government employers. The Job Accommodation Network is a free service of the U.S. Department of Labor's Office of Disability Employment Policy. JAN consultants have been providing job accommodation information since 1983, when JAN was founded. In addition, JAN consultants have been providing information about the Americans with Disabilities Act since 1992, when the ADA went into effect. Over the years, JAN consultants have developed practical ideas to help employees understand the ADA and request and negotiate reasonable accommodations in the workplace. The Employee's Practical Guide to Requesting and Negotiating Reasonable Accommodations under the Americans with Disabilities Act is a summary of some of the most frequent issues that employees have regarding accommodations and the ADA, and it gives JAN's practical ideas for resolving them. As new information is available or new issues develop, JAN updates and reflects the changes on the guide. And JAN also welcomes you to call them to share your story if, when you're reading over it, you see an issue that you have that is not addressed in the guide. You can always reach out to JAN. They welcome you to call and share your story so that they can put that on the guide, and hopefully it will help others who may have had a similar situation to you. So how do you know if you're entitled to the accommodation that you want? So to be entitled under the ADA, you must work for an employer with 15 or more employees. You must be a person with a disability as defined by the ADA. You must need the accommodation because of your disability. In addition, there are other accommodations if there are other accommodations that will meet your needs, besides the one that you are requesting, your employer is free to choose among effective accommodation options. Finally, your employer can deny your accommodation if providing it would cause the employer an undue hardship. So what is an undue hardship? What is it based on? It's based on the nature and the cost of the accommodation needed. So if this accommodation is going to put the employer at risk, then it might be considered an undue hardship. If the overall financial resources of the facility are not up to par, then it might affect the accommodation. If the type of operation of the employer, including the structure and the functions of the workplace, geographic separateness, and the administrative or fiscal relationship of the facility involved in making the accommodation, and the impact of the accommodation on the operation of the facility. So when should you request an accommodation? You can request an accommodation at any time during the application process or while you are employed. You can request an accommodation even if you did not ask for one while you were applying for the job, or even after receiving the job offer. Some examples of this would be a deaf applicant may need a sign language interpreter during the job interview. An employee with disabilities may need regularly scheduled breaks during the workday to eat properly and monitor blood sugar and insulin levels. A blind employee may need someone to read information posted on a bulletin board. And an employee with cancer may need to leave to have radiation or chemotherapy treatments. As a practical matter, it's best to request the accommodation before your job performance suffers or conducts problems, because your employers do not have to rescind the discipline that occurred before they knew about your disability. So for example, if you didn't tell your employer about a disability you had and you went ahead and tried to make the accommodation on your own, and if that didn't follow protocol of the company, you could potentially get disciplined for that. And then if you were to tell your employer after that you did that because of your disability, the employer does not need to rescind that discipline. It would still stand in place because they were unaware that you had a disability. How do you know what accommodation you need? So even if you're not sure what accommodation you may need, you can let your employer know that you might need an adjustment or a change at work because of this medical condition. Then you and your employer can explore accommodation options together. And it might also be beneficial to check out Ask Jan's A to Z Disabilities and Accommodations. If you're not sure of what accommodation may suit you best, but you know you need a change, it may be a good idea to check this out. You can search by disability, limitation, work-related function, topic, and accommodation. It's useful to check out what accommodations have worked for others to help you decide what accommodation will assist you best. How do I request an accommodation? According to the Equal Employment Opportunity Commission, EEOC, when an individual denies to request an accommodation, the individual or his/her representative must let the employer know that they need an adjustment or a change at work for a reason related to their medical condition. And there is absolutely no need to mention ADA or even use the phrase reasonable accommodation. Requests for reasonable accommodation do not have to be in writing and can be requested in a face-to-face conversation or using any other method of communication. Employers may choose to write a memo or a letter confirming the employee's request, or they may ask the employee to fill out a form or submit the request in a written form. However, the employee may want to put a request in writing even if the employer does not require it. Sometimes it's useful to have a paper trail in this case where there could be a dispute about whether or when the accommodation was requested. While an employer can't ignore the initial request, This request does not necessarily mean that the employer is required to provide the change. A request for a reasonable accommodation is the first step in an informal, interactive process between the employee and the employer. In some instances, before addressing the merits of the accommodation request itself, the employer needs to determine if the individual's medical condition meets the ADA definition of a disability, which is a prerequisite for the individual to be entitled to the reasonable accommodation that they are asking for. And this is a question that is asked by many. Do I have to tell my employer that I have a disability? So under the ADA, employers are only required to provide accommodations for employees who are experiencing workplace problems because of a disability. Therefore, unless you let your employer know that you have a disability, the employer is not obligated to consider accommodations under the ADA. So this is where it gets tricky. You have the ability to not disclose to your employer that you have a disability or share your medical information. However, if you do request an accommodation in the future, they have every right to deny it because they are not aware of this disability that you're experiencing. So how much medical information do I have to provide? When an employee requests an accommodation and the disability or need for accommodation is not obvious, an employer may require that the employee provide medical documentation to establish that the employee has an ADA disability and needs the requested accommodation. For example, you may want to tell your employer what you're having trouble doing, the problem that is related to the disability, and what accommodation ideas you might have. And if you don't have any accommodation ideas, you can let them know and work on that together, or check out Ask Jan's A to Z disability and accommodations list. If the employer does not ask for more information, that is also okay. However, employers have the right to request this information when you request an accommodation, just to see if your disability is under the ADA. If you do not provide it, the employer can deny your accommodation request. Some employees do not want to or do not like to give their employees a lot of details about their disability. So think about this, and if you prefer not to give a lot of your medical information, you may want to limit how much you initially give your employer when you request an accommodation. What accommodations can I request? So in general, an accommodation is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. Under the ADA, employers are required to provide reasonable accommodations for employees with disabilities. Therefore, you can request any accommodation that is considered reasonable. So if you're requesting accommodation that is considered reasonable, which we will go over later, then you can ask for as many accommodations as you need. Here are some examples of a reasonable accommodation, and this is from the EEOC, Equal Employment Opportunity, making existing facilities accessible, job restructuring, a flexible schedule, or a part-time or modified work schedule, acquiring or modifying old equipment, changing tests, training materials, software or policies, providing a service or qualified reader or interpreter, reassignment to a vacant position, provide reserved parking, the ability to take medical leave, and working from home. So all of these are examples of reasonable accommodations. So if anyone in their past has um, requested this accommodation or something similar to this and you are denied, I will let you know soon how you can file a discrimination against that. And maybe if you requested an accommodation that you believe was reasonable, but maybe got denied, you can try to use this as a guide to figure out where your accommodation may have went wrong and where you can maybe tweak it so that it can be reasonable. Here are some unreasonable accommodations. So these requests are not considered reasonable by the EEOC. Removing or eliminating an essential function from a job, lowering production standards, providing personal use items such as a prosthetic limb, a wheelchair, eyeglasses, hearing aids, or similar devices if they are also needed off the job. So while employers are not required to eliminate the essential function, lower production, or provide personal use items, they can do so if they wish. So they do not have to, but if your employer would like to, they may provide you personal use items or lower production standards or remove an essential function from a job so that you can maintain your employment there. However, employers do not have to do this for you because a qualified individual should be able to meet the essential functions for the job. So I have some examples that I would like to share today, and I'm going to give them in a poll form so that I can get feedback and see if we're picking up on some of the things that we learned about the reasonable and unreasonable requests. So this first one is going to be an employee tells her supervisor that I'm having trouble getting to work at my scheduled starting time because of medical treatments that I'm undergoing. So is this a request for a reasonable accommodation, or is this a request for an unreasonable accommodation? An employee tells her supervisor, I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing. All right, I'm going to close the poll and I will share the results. So great, so 88% of people think this is a reasonable accommodation request. And we have 12% of people who believe this is an unreasonable accommodation request. So 88% of you are correct. This is a request for a reasonable accommodation. As we learned in the past, making a flexible schedule or a part-time or modified work schedule is an accommodation that is reasonable by the EEOC. So this is what the person was asking for, just a modified or flexible schedule so that they would be able to make sure that they are receiving their treatments and getting the right amount of time. All right, let's have another example here. So an employee tells his supervisor that he would like a new chair because his present one is uncomfortable. Do we think that this is a reasonable accommodation request, or is this an unreasonable accommodation request? An employee tells his supervisor that he would need a new chair because his present one is uncomfortable. Great. So I'll close the poll and I'll share the results. So 27% of people think this is a reasonable accommodation request, and 73% of people think this is an unreasonable accommodation request. 73% of you are correct. This is an unreasonable accommodation request. So although this is a request for a change at work, his statement is not sufficient to put the employer on notice that he's requesting a reasonable accommodation if this employee had a medical condition where it stated that sitting for too long would give him issues, or that they needed a special kind of chair, then he could provide that to his employer, and then it could be considered a reasonable accommodation. However, just because a chair is uncomfortable is not considered a reasonable accommodation under the ADA. And we'll just do one more. This one asks, a new employee who uses a wheelchair informs the employer that her wheelchair cannot fit under the desk in her office. Is this a reasonable accommodation request, or is this an unreasonable accommodation request? A new employee who uses a wheelchair informs the employer that her wheelchair cannot fit under her desk in her office. And I'll close the poll and share the results. So we have 96% of people think this is a reasonable accommodation request, and we have 4% of people who believe that this is an unreasonable accommodation request. So I'm really glad to see that 96% of you voted for that this was a reasonable accommodation request, because that is true. Asking for a different setup at her office space because of an assistive device that she used is definitely considered a reasonable request under the EEOC and part of the ADA. So as long as her employer doesn't request any more information, he should be able to get this done for her right away. And even if she is able to give her medical information, it's sometimes not needed when you have a physical disability. It's just kind of up to the employer and the way that they would like to handle it. How long does my employer have to respond to the accommodation request? According to the Equal Employment Opportunity Commission, there is no specific amount of time that the employers have to respond to the accommodation request, but they should respond as quickly as possible. Unnecessary delays in responding or implementing an accommodation can result in a violation of the ADA. So the EEOC provides a few examples of this that I thought would be great to share. So example A is an employer provides parking for all employees. An employee who uses a wheelchair requests that the supervisor makes an accessible parking space, explaining that the spaces are very narrow and there's not enough room for his van to extend the ramp that allows him to get in and out of his vehicle. The supervisor does not act on the request and does not forward it to someone with authority to respond. When the employee makes a second request to the supervisor, still nothing is done. Yet 2 months after the initial request, no one has been told and nothing has been done. Although the supervisor never definitively denies the request, the lack of action under these circumstances amounts to a denial and thus a violation of the ADA. So even if your boss isn't replying to you or trying to make an effort to get you this accommodation, they can still be violating the ADA, even if they didn't outright deny it. Because it is, they should be able to do the accommodation request if it's reasonable as quickly as possible. Example B is an employee who is blind requests an adaptive equipment for her computer as a reasonable accommodation. The employer must order this equipment and is informed that it will take 3 months to receive this delivery. No other company sells the adaptive equipment that the employee needs. The employer notifies the employee of the results of this investigation and that they have ordered the equipment. Although it will take 3 months to receive the equipment, the employer has moved as quickly as they can to obtain the accommodation, and there's no ADA violation resulting from this delay. The employer and the employee should determine what can be done in the meantime so that the employee can perform his or her job as effectively as possible while they're waiting for the equipment. What if the employer denies my request? If your employer denies your request, try to find out why so that you know what you can do next. For example, if your employer denied your request because your medical information did not show that you have a disability, you can provide additional information. Or if your employer decided that the accommodation you requested would pose an undue hardship, you may want to suggest other options. So hopefully your employer will let you know if this poses an undue hardship, and maybe you and your employer or you and another support person can go over this and try to figure out how you can request something that doesn't pose an undue hardship to the employer. If you do not think that your employer had a valid reason to deny your request, or the employer will not tell you why the request was denied, you can appeal the decision by going up the chain of command, filing a grievance with your union if you have one, or filing a complaint with the EEOC or your state enforcing agency. So now I'm going to go over how you can file a charge of discrimination. So this is going to be really important information for anyone who may have had a job in the past and requested an accommodation and got denied. If you notice that it was a reasonable accommodation, check out how to file a charge of discrimination. Unfortunately, you will have a certain amount of time to file it, but you will know what to do in the future in case this happens again. So if you think you might have been discriminated against in employment on the basis of disability, please contact the US EEOC. A charge of discrimination generally must be filed within 180 days of the alleged discrimination. However, you may have up to 300 days to file a charge if there is a state or local law that provides relief for discrimination on the basis of disability. However, to protect your rights, it's best to contact the EEOC promptly if discrimination is suspected. So as much as it might feel like a good idea to wait and not tell anyone right away, you always want to let someone know, and especially the EEOC, so that they can help you and file a charge of discrimination or help you find out what you can do differently. So some of the enforcement action that has taken place in the past, I'd like to go over because it just sets a precedent for what goes on now. So the City of DeKalb, Illinois settlement agreement. This agreement bars employers from conducting medical examinations or making disability-related inquiries before a conditional offer of employment is made to applicants, and requires the employer to conduct training and designate an individual address to address ADA compliance and make its online employment opportunities website conform with the Web Content Accessibility Guidelines. So basically, this rule is just trying to help employers conduct training and have someone at their place who addresses ADA compliance, and someone who will conform with the website accessibility guidelines. The United States versus County of Ventura, This alleged failure to hire a qualified social worker who is deaf because of a reasonable accommodation to include a sign language interpreter. So when this social worker was hired or applying for a job and interviewing, they were qualified completely and they were not given the job because they would not give the accommodation of including a sign language interpreter. United States versus the City of Philadelphia, an employer failed to consider a reassignment for a sanitation worker who had a heart attack and was placed on a 20-pound lifting restriction. Instead, the employee was terminated. So in this case, we want to make sure that employees who come by hardships while they're on the job are still able to have employment, and a reasonable accommodation is moving them to a vacant position if that's something that will help them. So for a full list of all of these enforcements, which are really, really interesting, you can go to ada.gov's enforcement page, and I just recommend checking some of them out. And you might not even realize how little some of the things were, but it's important that they were filed a discrimination against so that we can see the enforcement happening and how new companies are starting to enforce this as well. The ADA also gives some technical assistance for people with disabilities seeking employment. So a guide for people with disabilities seeking employment is a 2-page pamphlet for people with disabilities providing a general explanation of the employment provisions of the ADA, how to file a complaint with the EEOC, and everything that you need to know. ADA Know Your Rights, Returning Service Members with Disabilities, is a 28-page booklet designed to provide military service members who have been seriously wounded a basic understanding of their rights under the ADA and where to turn for additional information and assistance. We also have a Guide to Disability Rights, which is a 21-page booklet that provides a brief overview of 10 federal laws that protect the rights of people with disabilities and provides information about how the federal agencies and who to contact for more information. There's also a questions and answers pamphlet about explaining the rights of people with HIV and AIDS under the Americans with Disabilities Act. Just requires the ADA, requirements of the ADA for employers, businesses, and nonprofit agencies that serve the public to avoid discriminating against people with HIV and AIDS. We also have the 10 employment myths. Many employers misunderstand the Americans with Disabilities Act and are reluctant to hire people with disabilities because of the unfound myths. So this video responds to concerns expressed by the employers, explaining the ADA in common sense terms and dispelling myths about this often overlooked pool of well-qualified employees. And after watching this video, I thought it did a great job of explaining the ADA and depicting what reasonable accommodations are. So I think it might be beneficial to share with you. Although you can tell this was filmed a few years back, many of the issues still apply today. So we're going to check out the video.
Footage shows protesters holding signs.
Before 1990, the world was a different place.
A protester sits in a wheelchair. Two women talk in sign language.
In the years since, the Americans with Disabilities Act has opened the way for people with disabilities to join the mainstream of American life. And yet millions of highly qualified workers still find the business community unwelcoming.
In a gym, a woman lifts weights. Her trainer sits in a wheelchair.
When I first applied for this job as a personal trainer, they were shocked. What could a person like me possibly do for a business like theirs?
Now, an older woman packs up her office.
As our population ages and baby boomers retire, America will lose 20% of its workforce by the year 2030.
An office worker opens a file drawer. Outside, workers load potted plants onto a trailer.
To maintain just the jobs we have now, without growing the workforce, the country needs to add 10 to 15 million new workers between now and 2015. Where will all these new workers come from?
A man in a motorized wheelchair reads the newspaper want ads.
One underutilized source of highly qualified new workers is people with disabilities.
In an office, women talk in sign language.
The ongoing removal of many of the physical barriers that literally barred the door have given many more people with disabilities access to higher education.
2.1 million people with disabilities are currently enrolled in college or graduate school.
Recent technological advances have made life easier for many people with disabilities. Many businesses also say they are counting on attracting and keeping the over 50 worker to help with the shortfall. Since 1 in 4 people over the age of 50 has a disability, keeping older workers on the job will require a new sensitivity to their needs.
In a warehouse, a man uses a hand truck to lift a pallet.
Like their younger counterparts, many need simple accommodations to keep them in the workforce.
Well, my bad hips was forcing me into retirement, and I talked to the boss and said that if he'd take me off the line and put me on the forklift, I could stay on. And now I'm manager of the warehouse, and everybody's happy.
What would you recommend? Studies show that 92% of consumers look favorably at companies that employ people with disabilities. 87% say they prefer to give their business to companies that hire people with disabilities.
Steve Russell, McDonald's USA.
At McDonald's, we absolutely know that in fact. We employ individuals with disabilities at all levels of our restaurant and staff organization. Many businesses across America are hiring people with disabilities for reasons that have nothing to do with charity, but everything to do with running a great business. And yet, many businesses are overlooking this important group of potential employees for reasons that have more to do with myth than fact.
Symbols, including a person in a wheelchair and a person using a cane, appear over the Department of Justice seal. A title, 10 Employment Myths. Myth 1.
Why don't I hire people with disabilities? I don't have a clue where to begin. I'm already overworked, and it's just too much trouble to find qualified people.
Warehouse foreman quote, "It's just too much trouble." Andy Washburn, Department of Justice.
Finding qualified people is always tough, no matter what kind of employee you're looking for. Many employers can feel overwhelmed, but it may not be as difficult as they think to actually find qualified assistants.
A website reads ADA Business Connection.
There are a lot of resources, both federally and at the local level, that can assist you in this process. Many employers are unaware that there's a $15,000 yearly tax deduction that can be taken to remove architectural or physical barriers. And there's a $5,000 tax credit that can be used to purchase equipment or modify equipment, as well as provide other services. We'll provide more information about these resources at the end of the video.
Words appear. Myth 2.
Frankly, my concern is that I might have to hire someone who has a disability, even if they're not qualified.
Shop owner quote, "I have to hire unqualified workers." Sally Conway, Department of Justice.
Well, you don't have to. Any candidate that you interview when you're looking for employees to fill any position, candidates have to meet specific criteria that you have determined that's necessary. And those are experience, prior experience, education, work history, all of those kinds of things. And that's very legitimate. And a person with a disability that comes to you to look for a job has to meet those basic requirements. If they don't, just like anyone else, they're simply not someone who's qualified to get that job for you. Now, what's clear? But if, on the other hand, they do meet your qualifications and they're the best candidate, you should hire that person with a disability. You have to remember that the ADA just simply levels the playing field for folks with disabilities and gives them the chance to compete for and be hired if they're the best candidate for the job.
Words appear. Myth 3.
I don't have to worry about hiring you. No one with a disability can do this for you. In my line of work, nobody.
Pharmacist. No one with a disability can do this job. Steve Russell McDonald.
You might never think of an individual with a disability as being able or interested in working for you. Some people see the disability while others see the ability. The fact of the matter is, people with disabilities can do most kinds of jobs today, especially with technology. Technology that we didn't think possible just a few years ago. People with disabilities can do all kinds of jobs, some that may surprise you. Individuals with disabilities are doing jobs like doctors, lawyers, pharmacists, computer programmers, restaurant managers, architects, and the list goes on. My recommendation is don't exclude individuals with disabilities from your applicant pool based upon stereotypes and false assumptions. You'll be missing out on a large and talented and diverse group of potential employees.
Words appear. Myth 4.
Well, I've thought about taking a chance on hiring a person with a disability, but it's far too risky. Once I hire them, I can't fire them.
Hotel manager. Once I hire them, I can't fire them. Andy Washburn.
Of course you can fire them. Your employees with disabilities are hired to do a job and need to be held as accountable as any other employee. The Americans with Disabilities Act does not require you to lower your production standards. Your employees with disabilities must be treated fairly and must be evaluated in a manner consistent with all other employees. It is true that some employees with disabilities will need accommodations in order to assist them perform the essential functions of the job. Having a disability does not shield an employee from having to meet performance standards or to adhere to workplace policies or rules.
Words appear. Myth 5.
Well, this is a busy office with usual office politics. It would really upset my other employees if I were to give special treatment to people with disabilities.
Office manager. My other employees will complain about special treatment. Loretta King, Department of Justice.
We don't give special treatment to people with disabilities. We provide them tools so they can perform their job. Just as we provide ergonomic chairs to individuals, special keyboards for people who might have trouble typing, or special lighting, screens for their computers, we're only providing them the tools so they can effectively perform their jobs.
Words appear. Myth 6.
The truth is, disabled people usually don't stay long enough to make all the time and money I spend worthwhile. And everyone knows they miss a lot of time.
Restaurant owner. People with disabilities are unreliable. Josh Mendelson, Department of Justice. Josh uses sign language.
People with disabilities are more reliable. Studies have shown that people with disabilities miss less work and have a less turnover rate than people without disabilities. Actually, Marriott Hotel did a study between 1999 and 2003, and the study showed that the staff with disabilities had a turnover rate of only 6% compared to people without disabilities. The rest of the staff had a higher turnover rate of 52%. So it really is a myth that people with disabilities are unreliable.
Words appear. Myth 7.
I understand disabled people might be able to do the work, but I'm not going to, because my insurance costs would go through the roof.
Bank manager. My insurance will go through the roof. John Wodatch, Department of Justice.
That's just not true. The Americans with Disabilities Act does not require you to provide your employees with disabilities additional healthcare benefits or different healthcare benefits than you provide to all your other employees. The Americans with Disabilities Act merely requires that you provide your employees with disabilities the same option as all the other employees have to participate in your group health benefit program. Now you should know that a Cornell University study has shown that an employer's health insurance rates rarely go up because they hire people with disabilities. But let me be clear, the Americans with Disabilities Act does not allow an employer to fail to hire a person with a disability because of assumptions that their insurance rates will go up because of that employment.
All right, so that video was just able to take us through some of the incidences that you might find when requesting an accommodation, some of the myths that you may hear as you are applying or as you hear other employers talk about hiring people with disabilities. And I think it's just a great way to debunk these myths. Showing a video of people that have disabilities continuing to do their job to the best of their abilities definitely shows that these are myths. So if you would like to watch the rest of this video, it is under the technical assistance, under the resources. Everything that I have shared and went over today is here on the resource page. If anyone has any questions after this is over, or if something comes up that you think of after this presentation, feel free to contact me by email or by phone number. You can also stay in touch with NJSAP by following us on Twitter, Facebook, Instagram, and checking out the NJSAP website. I'm going to look over some of the questions that were asked. Paul, is this also for high schools? I'm not sure exactly what you're referring to, but in high schools, they are able to give individuals with disability accommodations as needed. The A to Z list can be found in the resource page, or you can click the live link on the slide where we were discussing different accommodations and how you can search them. Do learning disabilities and ADHD that's required in an IEP in school qualify as a disability under the ADA? So a learning disability does generally qualify as a disability under the ADA. As I said earlier, the ADA doesn't have a list of which conditions are disabilities. So it might be a case-by-case basis here. If the employee has a learning disability and ADHD and there is a reasonable request that can be made, then I'm sure that the employer would make that accommodation happen. Must I file a claim with NJOCR before EEOC? I would recommend doing EEOC first and then NJOCR. EEOC is going to look at all of them, no matter where you are and where you live. And it's always great to report it to your state agency as well, so that they can provide more assistance when it comes to on a state-by-state basis. However, we do want everyone to know about this discrimination so that it can be used in the enforcements for places all around the world. So it doesn't really matter which one you do first or last, but I would definitely do both. Should the ADA be taught in all high schools? The ADA should definitely be taught in high schools. I think that when high schools tell us that they're preparing us for the real world and getting a job, oftentimes the ADA is not touched upon, and it has, as we know, the individuals with disabilities hold a very big population, especially in our workforce. So we need to keep educating individuals about the ADA so that people who grow up to start their own businesses and become employers know these rules and that they don't have to start from scratch with it. So I do think ADA should be taught in high schools, but we will see where that takes us. And again, if anyone has any other questions that I have not addressed, feel free to email me or call me and I will address any other questions. All right, thank you all, and I hope you have a great day.